Now turn to the second case on this morning's docket. That is case number 104392, State of Kansas v. Jonell Lloyd.
May it please the Court. I'm Deborah Wilson from the Capital Appeals and Conflicts Office. I represent the defendant appellant, Jonell Lloyd. Justice Ness, I'd like 3 minutes rebuttal time this morning.
3 minutes is granted.
Thank you. Mr. Lloyd was convicted of first-degree murder, the case involving his young daughter, Shavira. The case was submitted to the jury on both means of committing first-degree murder, both premeditated intentional murder and felony murder. The jury convicted him under both theories, and he was subsequently sentenced to a hard 50 sentence. The first issue on appeal is Mr. Lloyd's challenge to the sufficiency of the evidence on the theory of premeditated murder. In a nutshell,
are we restricted to what the state argued on premeditation? All the argument is whether the baby was alive or not, but if the baby was dead, the very fact that the child was instead of calling 911 in a panic, as often happens, we put it in a trash bag and hide it, would be evidence of premeditation, even if the baby were dead at the time.
I think you're right, Justice Johnson. You're not restricted to the state's theory of premeditation, although there was only one theory of premeditation argued in this case, that she was still alive when she was placed in those bags. However, I looked at other possibilities for premeditation because I've been back and forth through these facts over and over again, looking for something to establish that. And here's the problem with the state proving premeditation. You have to consider the pathologist's testimony about how this child died. The pathologist said the child was asphyxiated. And the pathologist said very clearly, I don't know how. He said, I can't explain the anatomic death. I don't know the mechanics. I can give you various scenarios that would cause an asphyxiation, but I can't tell you how. And he said, however, that in this case, the asphyxiation was not an immediate thing that happened. He said there was an initial trauma. Which could have been a choking, could have been a suffocation, and the initial trauma was fatal. There was a fatal initial trauma, but it didn't immediately kill the child. Because of his findings of brain swelling and early pneumonia in the child's lungs, what the pathologist said happened was this. There was an initial trauma. The brain was fatally deprived of oxygen. The cortex died with that initial trauma. However, the brainstem didn't die immediately. And so the child continued to breathe. The child continued to be alive for a period of time. And I think he said maybe an hour, maybe 2 hours. What that means for premeditation is this. Whoever abused Shavira in a way that caused that initial trauma stopped while Shavira was still alive and breathing. So that argues against, that strong forensic evidence against an idea of premeditation, because if a person intended to kill the child...
If a person shoots someone and they're bleeding, but they don't die immediately, then if they don't continue shooting them with additional rounds, then it's not premeditation, even though they intended to kill them when they shot?
No. I mean, obviously that can show premeditation.
It's the same way with when you put a baby in a bag, plastic bag.
Right, and that's
it's like leaving a gunshot victim to die of loss of blood.
If the child was alive when placed in the bags. But the only facts established by the evidence in this case, they don't prove the child was already dead when placed in the bag, but they certainly suggest the child was already dead. Rather than...
Even if the child wasn't placed in the bags, the child was left to die. The child was left to die. No one sought medical attention for this child for some period of time more than 1 or 2 hours after this abuse occurred.
But we would have to believe that the person who inflicted this abuse on Shavira and stopped the abuse while she was still alive, while she was still breathing, we would have to infer that that person knew somehow, oh, her cortex is dead, it's only her brainstem.
No, all we have to infer is that the act was done with the intent to kill, and we don't have to infer anything. The jury does, and that was all laid out, and defense was entitled to argue, hey, this doesn't show premeditation because defendant quit choking. But that's the jury's choice to determine what it means and what the evidence means. And they made that choice.
Well, but they, I think, believed that the child was dead when placed in the bag, because that's all that was argued to them. And
Being alive.
I'm sorry. They would have to believe that the child was still alive when placed in the bags, because if you look through the argument in this case, that's all the prosecutor ever said. The prosecutor never said failing to get medical attention for this child who appeared to be alive to you shows that this person intended to kill her.
Now, where do you get that the child appeared to be alive?
Or appeared to be dead. From Tamika Loudermilk.
What are we doing with Loudermilk?
Oh, I'm sorry. I misunderstood the question. What I was saying is the person who abused Shavira stopped the abuse while she was still alive, and was probably hoping that she would be better. But
do we have any testimony that the actor here, the defendant, was able to observe or to know that she wasn't dead? Because Tamika said she looked dead.
Tamika said there was a period. Tamika testified. I'll give you the sequence of events
that
here.
There was some choking.
Right.
And an hour of crying while it sounded as if she was choking, as I recall.
Well, she I think,
minutes to an hour.
revised that. She had said, there was abuse for an hour, and then I think she revised that too.
But she did. But I mean, if you take the evidence in the light most favorable to the prosecution, there's evidence of up to an hour of choking sounds.
Here, Tamika sees Jonell strike Shavira with the belt. Shavira cries for 20 minutes. That's at Volume 10, 146, 147, Volume 11, 19. Then, at some point, Tamika sees Jonell choke Shavira. Then, Tamika hears Shavira's labored breathing for 10 to 15 minutes. And then, at some point, Jonell paces. But there's no... So, the labored breathing went on after this choking incident. So, and like I said, I don't think we can infer that this person knew, this was a fatal incident, she's going to die eventually.
I'm very confused, and I guess I'm not understanding what your argument is on the whether or not the child was alive or had already died at the time he put her in the plastic bags. What difference does that make when you have evidence of strangulation, extensive evidence of strangulation over a period of time? That we've said is evidence of premeditation all by itself. Why isn't that simply evidence for the jury to decide whether there was premeditation or not? What difference does it make?
Because
whether she was alive or dead?
Whoever did it stopped. Whoever did
right,
it
but that's a
didn't
question
continue
of
until
fact.
she
I'm
died.
saying, why isn't that a question of fact for the jury to decide? Why does it matter whether she was alive or dead?
Because that was the state's entire theory of premeditation.
That was their closing argument.
Right.
But the evidence they presented was about a lengthy strangulation.
If you take a look at...
We're talking about what the sufficiency of the evidence presented, not their closing argument.
I think there was evidence of a lengthy spanking, but the evidence of the choking, which is at Volume 10, page 148, 149, I don't believe Tamika Loudermilk put a time on that.
She said 15 minutes to an hour of the sounds of choking. My point is, why isn't that a question of fact for the jury to decide what his intent was?
But that was the agonal breathing that she was hearing. You said you heard the child breathing, trying to catch her breath. That wasn't the choking incident. That was after this asphyxiation incident where she was involved in the agonal breathing that the pathologist testified. You said that went on for what, 10 to 15 minutes? That's at volume 10, page 156. There's not evidence in this record of a lengthy
There's evidence
choking.
of strangulation.
Correct.
Why isn't that a question of fact for the jury to decide whether he premeditated and intended to kill her?
As I said, I'll just say it again. If whoever harmed her in this way stopped while she was still alive, it's not a very efficient way to kill someone by strangulation if you stop while they're still breathing and then take no further steps to ensure the child doesn't breathe anymore. And that's why the state argued she was alive when she was put in the bags. The state recognized that as well. The person who harmed her stopped while she was still alive, appeared to be still alive. Yes, it's true no one in that house sought medical attention for her, but they didn't know, unless they were medical experts, that, a fatal incident has already occurred and we're just waiting for the process to work its way out. I'll move on to the second issue in this case. This concerns Mr. Lloyd's claim that Tamika Loudermilk's statement and trial testimony were involuntary, that they were coerced, and they were therefore not reliable and should be stricken from the record. The record establishes a colorable claim with regard to this, but because of trial court error, the record stops, unfortunately, at colorable. Ms. Loudermilk was arrested at her home. Her child was taken into protective custody. And while the police were questioning her, she told them, I don't have any information. I can't help you with this. I can't assist you in your investigation. I don't know anything about Shavira. Until they told her, your infant son is going to be taken from you, placed in foster care, and adopted by strangers if you don't cooperate with us. Then she accused Mr. Lloyd of this crime. No less a tribunal than the United States Supreme Court has found that threatening to take a person's children away unless they make an incriminatory statement constitutes coercion. And the state doesn't argue anything to the contrary. The record, however, stops at a colorable claim because Mr. Lloyd was on his own in trying to bring this to the trial court's attention. In presenting the motion to strike to the court, Mr. Lloyd's own lawyer discredited it and disclaimed it. And apparently Mr. Lloyd was the only person in the courtroom who correctly believed that he had standing to challenge the voluntariness of a witness's statement. And the state doesn't disagree with that legal proposition either, that a criminal defendant may seek to suppress or strike the testimony of a witness if it's given under coercive circumstances.
Was there a motion to suppress filed in this case on this statement?
No.
And
No.
was there any, and there was no contemporaneous objection to the statement coming in at trial?
No.
Either through the witness or the police officer, the detective that.
Right.
And so you're wanting us to look at an after-the-fact objection way down the road?
Yes, I am.
And tell us why we should do that.
Because you're going to be looking at this issue eventually anyway. This can be handled as trial error because the trial court erroneously believed that Mr. Lloyd didn't have standing. His own lawyer erroneously believed that he didn't have standing. So this could be brought in a 60-1507 motion. This could be brought on a request for post-conviction relief. I brought it in the direct appeal because I believe the record is clear enough that he, in fact, had a colorable claim of coercion. And so my position today is, by the way...
But the colorable claim is a long ways from saying that factually she was under coercion at trial. I think you have a lot better argument about the statement when they arrest her for obstruction and take her child away, and that you have a much better argument. But wouldn't you agree that that's harmless error if she voluntarily, without coercion, testified at trial?
I would. I wanted to say something to Justice Rosen, and then I'd like to follow up on your comment, Justice Johnson. Justice Rosen, I'm not asking you today to find that this is involuntary. If you look at my brief, I cited that Salvucci case from the United States Supreme Court that would allow you to remand this for a full and fair hearing. So I certainly don't think this court is in the position to say, oh, yes, she only made these statements under coercion, because the record isn't sufficiently developed in this case. Now, Justice Johnson, you're right that it could be harmless error if they find that her trial testimony wasn't coerced. And so and that's why I cited those cases in my brief about how if the coercive circumstances continue at trial, then you can also have the trial testimony stricken. And in support of that, I'd like to cite to you to Volume 11, pages 3 and 4, pages 37 and 38, pages 54 and 56, and then Volume 12, page 132. What all of those record sites show you is that the child in need of care proceeding with regard to the child who was taken from Tamika Loudermilk was still ongoing. And the child had not been returned to her custody when she gave her trial testimony.
The problem I have with that is that once you institute the child needed care, you have a whole different scenario. Mm-hmm. And the judge presiding over that will not just say, okay, she has fulfilled her obligation to testify, so we're going to send the child home. No, that's the court's going to only operate in the best interest of the child. That's a whole different scenario, and whether she testifies or not is not going to drive the wagon here. So where is the coercion?
The coercion is saying your child is going to be put up for adoption unless you cooperate.
But the prosecutor doesn't make that determination. Once you have a child needed care proceeding, the court has to, by statute, operate in the best interest of the child, regardless of what vengeance the prosecutor wants to extract for failure to testify. That's not going to accomplish anything.
That's absolutely true. However, we have no idea, because Mr. Lloyd wasn't able to develop his claim because of trial court error. Oh, you don't have standing to bring this claim. We have no idea whether she's been told by police officers, by detectives, by victim witness coordinators that your cooperation in this prosecution will help you in your child in need of care case. Your failure to cooperate in this prosecution will result in your child being adopted. We don't know those things because Mr. Lloyd didn't have a full and fair hearing on his claim. So, I mean, you're right, Justice Johnson, you bring up a lot of circumstances that we don't know about. That's true, we don't, but that's because of trial error, because no one believed he had standing other than the defendant himself.
I understand. Before you sit down, you made an argument with regard to your third issue on 6455 evidence dealing with the limited instruction. Volume 1, page 96 appears instruction number 17 that looks a lot to me like a limiting instruction.
And I think the prosecutor will let you know that was added after I filed my brief. I requested the instructions in this case, and so when I filed my brief,
So you
I
agree
didn't
there
have-
was a limited instruction
I do.
in this case? Okay.
I do.
So that's
but
off the table.
That was added
Okay.
after I filed my brief.
Okay, thank you.
Thank you.
Do we have any further questions of counsel before she sits down? Thank you, counsel.
May it please the Court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state. And just to clarify on that, Justice Johnson, when the record was initially prepared, the instruction packet that was made part of Volume 1 was incomplete. And we discovered that at the time of the drafting of our brief and filed a 302, and now the instruction packet is complete. So just to clarify that point. The first issue before the Court today challenges the sufficiency of the evidence to support defendant's conviction for premeditated first-degree murder. And the standard before this Court in analyzing that claim is whether the evidence is sufficient when viewed in the light most favorable to the state to support that conviction. The evidence that was presented to the jury included the testimony of forensic pathologist Dr. DiStefano, who testified that Shavira's cause of death was prolonged asphyxiation, as evidenced by the early onset of pneumonia in her lungs and as evidenced by the substantial swelling in her brain, which was a condition that took several hours to manifest. Additionally, the doctor testified that both the condition of the body and the cause of death were consistent with being enclosed in 3 separate trash bags as well as a cushion cover. The defendant's challenge is twofold. First, that there was a failure to present evidence that she was still alive at the time that she was placed in the bags, and a failure to present evidence that the defendant was aware that she was alive when she was placed in the bags. And I think in analyzing that claim, we have to look at a general timeline of events from that day. Both Tamika and the defendant testified that the defendant woke Shavira from her nap and beat her because she had pottied in the bed. Defendant testified that that was approximately 2:45. Tamika testified that the beating lasted approximately 20 minutes, which places us roughly between 3:05 and 3:10. A short time later, she exited the room and observed defendant with his hand over Shavira's throat. We're now loosely between 3:15 and 3:30. Shortly thereafter, Tamika heard noises like Shavira struggling to breathe that lasted approximately 15 minutes, which bumps us to approximately 3:45. From that point, the defendant moves Shavira to the back room, which is the last time that Tamika sees the child. She's placed in a trash bag at that time. He moves to the kitchen, grabs 2 additional bags, returns to the room, places the first bag in the second, knots it off, the second and the third, knots it off, puts it in the cushion cover, takes her to the attic, the far side of the attic, and places her behind the ductwork. He then takes Tamika's phone and makes a phone call. Jessica Jackson testified on rebuttal and verified through her phone records that the first phone call that she received from defendant was at 4:33 p.m. She received 3 phone calls at that time. That is consistent with the defendant's testimony that when he became alarmed that the child had allegedly disappeared, his first phone calls, plural, were to Jessica, and when he could not reach her, he attempted to contact LaDante Alford. That's also consistent with the testimony from Elvin Freeman, who testified that he also received a phone call from the defendant around 4:30 or 5 o'clock asking for Freeman to come and pick him up. Now, we know she's still alive and placed in the bags because at 2:45 she's awoken from her nap and beaten. The testimony indicates that she sustained a beating for approximately 45 minutes to an hour. Jessica Jackson receives her phone call 1 hour later, approximately, which is 4:30. If we are to believe that Shavira was dead when she was placed in those trash bags, it would require us to wholly discount the testimony of the coroner, who stated that the swelling in her brain was a condition that took several hours to manifest, a minimum of 2 to 3 for brain swelling. But in this case specifically, he testified it was several hours in order for that swelling to continue.
When was she found, Ms. Isherwood?
It was, I think, Detective Landwehr or Lieutenant Landwehr testified it was around 12 to 15 hours later, so it was actually probably early the next morning.
Day.
The dispatch went out at 8 o'clock, and then it was several hours after that. How do we know that defendant's aware that she is still alive? Tamika testified that she was gasping and gurgling for air around the time that defendant was choking her. The coroner testified that following the choking and drink, and let me just back up a minute with respect to how we know she's still alive. The coroner specifically testified that his findings did not support a finding that she died as a result of the choking.
he did testify that following the choking injury that she would continue the breathing process. And he likened it, although he called it a bad analogy, he likened it to the brainstem sending the impulses for the body to continue to breathe. Additionally, the early onset of pneumonia is a condition that results from the victim vomiting and aspirating that gastric fluid into their lungs and then attempting to breathe. So there were physical indications this child was still exhibiting signs of life as she struggled. Additionally, the defendant's own conduct of placing the child in 3 individual bags, a cushion cover, and then placing her in a distant area of the attic is the state's position exceeds what would be, I hate to use the word necessary, but what would probably be similar to simply trying to conceal a body. For those reasons, the state would argue that there is sufficient evidence before the jury. The defendant has provided a timeline to this court through their brief and argued that if this court views it differently than the way that the jury viewed it, then there's a different outcome possible. But that's not the standard. The standard is, when we look at the evidence in the light most favorable to the state, is it sufficient to support the jury's finding? And the state would argue that that finding is there.
But you will agree that we're precluded from stacking inference upon inference.
I would agree, but I don't think that's necessary in this case.
Well, if premeditation is to be inferred from the act of placing a live child in a plastic bag, and the fact that the child was alive is to be inferred from the length of time for the brain to swell and pneumonia to be evolve, why isn't that stacking an inference upon an inference? Because
the defendant knew that she was alive. She was exhibiting signs of life. I don't think it's an inference.
I thought Tamika testified that when he carried her back to put her in the bag, she appeared to be dead. The child appeared to be dead.
But that's not the only testimony. We also have the testimony from the pathologist who indicated that there would still be signs of breathing and that there would still be indications that the child would be vomiting. There are still signs of life being exhibited. We have to understand that the defendant is the one that's in close proximity to the child. He was holding it against his chest as he carried her. Tamika was in another room.
And so you're inferring the defendant's knowledge of her being alive from the pathologist's testimony.
I don't think that has to be inferred. The pathologist has told us that she's exhibiting as signs of life until she expired. It is reasonable to conclude, a rational fact finder can find, that defendant being in close proximity to the child as he's placing her in a plastic bag is aware that she's still alive.
But that's inferred from the circumstances.
And circumstantial evidence has no less probative value than direct.
Exactly. But if you're inferring from circumstances and then you take that inference and use it to make another inference, that's what we've said is impermissible.
And I guess we would have to agree to disagree, because the circumstantial evidence demonstrates that she's still alive. The circumstantial evidence also demonstrates that Tamika wasn't the one that placed her in the plastic bag. The defendant was the only other one in her presence. He placed a live child inside a plastic bag. The circumstantial evidence demonstrates that the defendant is the one that intentionally and premeditated the death of Shavira Brown.
My understanding of a point that you were attempting to make a few minutes ago, and maybe you did make, was that because of the length to which the defendant went to not just put the child in a bag and put it in an attic, but other things, several bags, knotting the bags, etc., you thought that was independent evidence of his knowledge that the child was still alive, and he wanted to ensure that it would not have any air and therefore would die. Is that your point?
Correct.
Okay.
That was additional evidence before the jury from which they could conclude that the defendant intended to ensure her death.
Infer. That was additional circumstances from which the jury could infer.
It was additional circumstantial evidence of his premeditation.
I guess I want to clarify, because I want to make sure I understand your argument. Do you concede that you need to make those inferences about the timing of the child's death to have evidence of premeditation?
I believe so, just because we don't have Tamika specifically there, present next to the defendant through the entire time. She's not documenting each act, but when we...
Yes, well, I want to be more specific, because what I'm getting to is when you have a child that's a year and a half old and you have evidence of strangulation of this child, is that a circumstantial piece of evidence that's significant all by itself? Just the age of the child, the inability to defend the child's self, that is evidence that was an intent and a premeditated intent?
Absolutely. The jury could have also relied upon that. The jury is not necessarily bound by the theory that's put forth by the prosecution. The jury is bound by the evidence that's presented to them and what they are required or what they can use to reach the finding of premeditation. So absolutely, that is evidence that they could rely upon.
And I guess that's what I really want to crystallize on. Is there really evidence of premeditation there, even circumstantial, or is it really just an evidence of an intent to kill?
I think it would be more evidence of the intent to kill.
Right.
I think the premeditation comes in with the fact that we have circumstantial evidence that she was still alive, and the defendant took the additional measures not to seek medical attention as she's still continuing to struggle, but he takes measures to ensure her death.
And this is why I wonder whether she was alive when she was placed in those bags matters at all. No one in that house took any steps to save this baby.
No,
for hours.
That's
for
correct.
Hours. So however many hours it took for her to die after the strangulation and the beating that preceded it, no one did anything to help her for hours. Isn't that adequate evidence of premeditation, regardless of whether she was alive or dead when she was placed in those plastic bags?
That would be adequate evidence, but I think we need to move forward to I guess I'll use your word, to crystallize and to actually establish the premeditation.
I understand the state's theory. I think completely you've done a good job of explaining it for us today. I understand that theory, but as you've also said, and I think as all of us have acknowledged, including your opposing counsel, the jury's not bound by the state's theory. They're bound to decide on the evidence presented. I'm just asking you, wasn't there adequate evidence of premeditation, regardless of whether the child was alive or dead when placed in those plastic bags?
Okay. Can I carry through with that?
Sure.
Premeditation, by definition, is to have thought the matter over beforehand.
Yes.
And if there's a choking, and then the child is obviously in stress, and then the actor does not help the child and just determines, I'm going to let the child die, is that premeditation? Even though the intent to allow the child to die or thinking about letting the child die occurred after the physical act. Do you follow what I'm saying?
I do follow what you're saying, and I think it kind of goes along with the analogy that you presented to opposing counsel with the shooting. I mean, it's still ensuring her death by failing to act.
But my example on the shooting was intend to kill with the shooting. And here there would have to be an intent to kill with the choking, even if you stop before you got it complete with the choking part, you just let them die.
I think
let them bleed to death. But what I'm getting at, my question is, does the thought about intending to kill have to happen before or concurrent with the choking, or can that be formed after?
I do believe it can be formed after, and I think in part it was formed after in this case by ensuring the child's death by then placing her in the bag. So that premeditation carries forward with his additional actions.
In your view, is there sufficient evidence for the jury to conclude that the premeditation and intent to kill occurred at the time of the initial choking And there's also sufficient evidence to suggest that if it did not occur at that time, it certainly occurred at some point afterward, i.e. the placing of the child in the bag. And what I'm getting at is, as we're looking at analogies, contemplate the possibility that someone decides ahead of time that they want to inflict a painful death on you. And they do just enough to inflict the pain, and they stand back and watch you die an excruciating death. So their premeditation and intent would have been formed before the act.
Right.
So my point is it your belief that there is or is not enough evidence in the case to suggest that something like that occurred in this case, or does your case depend upon the intent or premeditation to have occurred after the choking and basically at the time of putting the child in the sack?
I believe that the evidence is stronger for premeditation in placing the child in the bags. That his intent was, or his premeditation was more evident in placing the child in the bags and ensuring her death by layering the bags and placing her within the couch cushion. I don't know that we can really necessarily bifurcate it that way. I think it's all one act, but I think that the premeditation is definitely evident by placing her in the bags.
Okay.
With respect to the second issue, this challenges the court's ruling on a matter that the defendant raised independently during his portion of the case regarding Tamika's interviews with the detective. And first of all, I want to clarify that no one in that room alleged that the defendant lacked standing. Now, the court said, I don't necessarily agree with your theory that the analysis is the same as far as a witness's statements and a defendant's statements, and I would agree that the court was wrong in that respect. But in reading the court's ruling, there is certainly no assertion from anybody that the defendant lacked standing. That is not what this ruling was based on.
But you agree the court made an incorrect ruling?
I would agree. 2 days after Tamika testified and after the state has rested its case and we're 6 witnesses into the defendant's case, defense counsel comes forward and says, defendant has provided me with this case that he alleges stands for the proposition that if Tamika's statements were coerced, that they can't be introduced against him at trial. That was the extent of the legal and factual argument that was presented to the district court. The court indicated it wanted to take the matter under advisement and it would issue a ruling at a later time. When they reconvened for that ruling, there was no legal or factual argument presented then. At the conclusion of the court's ruling, he said specifically, I'm going to hold this open. If anyone has any additional facts or argument they wish to present, please feel free to do so. We never heard anything else about it. Whether a witness's statements are coerced by detectives is a factually driven argument similar to when a defendant's personal statements are being suppressed. And we certainly don't have that factual foundation here. In his brief on appeal, the defendant acknowledges that Tamika was never questioned whether she felt duress or coercion, yet asserts that his conviction should be reversed because her statements were coerced. He cited many cases on the issue of what should happen when a witness's statements are coerced, but an analysis of each of those cases indicates that the matter was developed factually before the district court and not before the reviewing court. We simply don't have that foundation here. Moreover, as Justice Johnson stated earlier, we can't lose sight of exactly what would be extracted here or what would be limited here. The limitation on her testimony to the detectives does not exclude her from testifying at trial. The case that the defendant cites for that proposition indicates that that testimony can only be excluded if the defendant satisfies his burden to demonstrate that there's been ongoing coercion and that coercion has directly impaired the reliability of her testimony. And we don't have that here, other than whether there's some question of whether her sink case was ongoing at the time of trial. In fact, Tamika believed that her sink case was concluded.
Counsel, could you state for me what you believe our standard of review is on this particular issue?
I think it's a little bit complicated because I guess I would have to say the adequacy of the legal basis, but which would place it under a de novo review. But it's a little bit complicated because it was never legally or factually established whether the court necessarily had all the tools it needed to make the correct legal determination. So I guess at the most fundamental level, it would be a de novo review.
There had been some suggestion, I thought, in opposing counsel's position that this could have been brought later as a 60-1507, which would suggest that maybe there had been some sort of a waiver or ineffective assistance by opposing counsel, if I understood her point correctly. Does that enter into your calculus at all?
Well, I believe it could certainly be an allegation. He's free to make any allegation he wants in a 60-1507, and I would assert that that would be the appropriate avenue at this point, because we certainly don't have enough evidence before this court to make the determination, and the defendant had 3 opportunities to raise this before the district court, so remanding it for an evidentiary hearing to do what he failed to do 3 previous times is certainly inappropriate. As far as an ineffective assistance of counsel claim, I believe that counsel probably didn't move forward with the defendant's position, because to do so would be to use Tamika's statements as both a sword and a shield. She had already targeted Tamika's statements as being unreliable, and she had extracted the value from those statements that she made to the detectives, and now to turn around after I've used them and say, oh, those can't come in, would be inappropriate on her part. She can't use them and then exclude them. And I would assume, and we don't have the record for that, that may be one reason why she didn't move forward with the defendant's argument. But I see I'm out of time. If there are no further questions, the state would respectfully request Justice White.
Before you sit down, you made a comment just a moment ago about a remand at this stage being inappropriate to develop the factual record to determine whether the legal issue was correctly decided.
Right.
That would be inappropriate. You said a reason, but I just missed it.
Because he's had 3 times to already
At
to
the
do
district
that.
court.
Yes.
Right, but I think that perhaps the issue is whether a remand to the district court to do it now would be inappropriate. And is it your position that would be inappropriate because it hasn't been sought?
Well, my position would be inappropriate because he sought that he had an opportunity. We would be rewarding his failure to bring it 3 previous times by remanding it for he's lost his opportunity.
I think we're still failing to communicate. You appreciate, I know, that a defendant on direct appeal can't normally raise an ineffective assistance of counsel claim.
Right.
But that if that defendant desires to do so, he or she may ask for a remand to district court on that issue. That is a procedure that can be sought at that juncture.
First, I'll say yes, but second, I will say that hasn't been requested here.
So isn't that really the reason that we shouldn't give that sort of relief? The very first reason is that it hasn't been sought?
Sure.
Okay.
Well,
thanks.
you're really saying that we have an insufficient evidence here, or lack of sufficient evidence, because the defendant was provided with an opportunity to present evidence of coercion, failed to do that, so that was his chance to do so, and he doesn't get a second bite at the apple, is what you're saying.
It would actually be a 4th bite at the apple, but yes, that's what I'm saying.
With regard to the 6455, real quickly,
sure.
I understand that you're making some argument that defendant wanted some of that evidence to come in to show for defense. Is that what you're arguing?
Well, it's not my argument. It's what defense counsel presented specifically pretrial below.
But there's a difference between whether there's like a warrant outstanding and the actual act, isn't there? I mean, just because someone wants part of that information doesn't mean it all has to come in. Doesn't it all have to be relevant?
Well, and it's the state's position, just like they argued below, that the details are relevant because it speaks to Tamika's conduct. It offers an explanation for an otherwise inexplicable act that she sat idly by as a mother and allowed this to happen, and that it also is relevant for purposes of her credibility. If there are no further questions, the state would respectfully request that the defendant's convictions for the abuse and intentional premeditated murder of Shavira Brown be affirmed.
Any further questions of counsel? Thank you. You reserve 3 minutes for rebuttal.
Thank you. I'd like to reiterate again, I stated this in my reply brief. I've never argued that the state failed to prove that Mr. Lloyd knew Shavira was still alive when she went in the bags, because that argument presupposes the very fact that we contest, that she was alive. And as I was listening to the state talk to you about this series of events, I heard the time 2:45 come up. And so I looked in the state's brief to find where there was a citation to the record of something occurring at 2:45, and there is no such citation. I would urge this court to look at pages 17 and 18 of my brief, and I have searched the record for every time we can place a time on an event. What that reveals is that Shavira was last seen outside of her house at the latest, giving the state the benefit of this evidence. At the latest, she was seen at 1:45 in the afternoon. Then Tamika sees Jonell strike Shavira with a belt, and Shavira cries for 20 minutes. That's at time unknown. We don't know when that happened. Tamika didn't give a time for that. Then the next thing that occurs is Tamika sees Jonell choke Shavira. Once again, the timing for that is unknown. Then Tamika hears Shavira's labored breathing for 10 to 15 minutes. The timing for that is unknown. Then Tamika sees Jonell pacing. When did that occur? Once again, we don't know. And the prosecutor has described a process of Tamika seeing Mr. Lloyd placing Shavira in these bags. That is not in the record anyway, because she never testified she saw Shavira go into the bags. Then we do have a time, 7:32, Jessica listens to Jonell's voice message regarding Shavira. That's Jessica is the mother of the child. So what we have here is a time period from 1:45 until 7:32 where we have some events, but we don't know what the timing of those events are. Why is that important? Well, it's important because if there was evidence that soon after a choking event, Shavira was placed in the plastic bags, then that would support an inference that she was alive when she was placed in the bags. But there's no information about timing in this record. So what we have is a period of time from 1:45 in the afternoon until 7:32 where some act of abuse resulting in asphyxiation could have occurred, a period of labored breathing could have occurred, death, and concealment in the attic could have occurred. But we just have to guess if we want to assume that Shavira went in the bags alive.
And we also have 3 trash bags and a cushion cover utilized, which is at least somewhat unusual.
Yeah, I hate to be gruesome, but of course if you're concealing a body, a dead body, you want to make sure that smells don't escape. And if I could talk about those bags for a minute, remember there were bugs and bug parts in those bags. Shavira didn't inhale any bugs or bug parts, even though there were bug and bug parts adhering to her skin around her mouth and nose. The pathologist...
Was the pathology testimony, did it go at all to how shallow or deep the breathing would have been after a strangulation incident of
No,
this
he
sort?
didn't. But it's not this court's job to supply facts in the record, no matter how horrible the crime is. I'm really afraid that our disapproval, our revulsion at this crime is, I would hate to see us substitute disapproval and revulsion for proof beyond a reasonable doubt. And I certainly hope this case isn't the case where the Kansas Supreme Court says premeditation can occur after the fatal event. That would...
Well, I want to ask you about that because, Justice Beyer's question about the time period where before she goes in the bag, but we know at least 15 minutes to an hour of labored breathing following whatever the incident was, the choking incident.
Right.
So we know she's not dead then. Disregard the bag. We know for at least that time period there's an opportunity to try to help her to prevent her death. is that evidence of premeditation, or is that simply, again, just evidence of a failure to respond to an intended killing or an intended death, I guess? I'm not sure. I'm trying to distinguish because we have said that things that happen after the event itself, those factors can come in to play as far as premeditation, but I'm wondering how that relates to this case.
Right, and they can come in to play afterwards, but you're still trying to determine what the state of mind was beforehand.
Right.
That's circumstantial evidence of the state of mind beforehand at the
Right.
time of strangulation. But what I'm suggesting is that we may all be viewing the event, the fatal event, a little narrowly here. Because it was the leaving her alone with no assistance after the strangulation, in addition to the strangulation itself, that killed her.
Well, I mean, not to quibble, but I think according to the pathologist, that process had already started. But I think to infer an intent to kill or premeditation from the fact that they didn't seek medical care, or whoever harmed her didn't seek medical care, I think then we'd have to infer some medical knowledge that obviously neither person in this house had, that, this child is dying, as opposed to, I went too far in my punishment, I'm hoping she'll come to. I don't think we can establish premeditation in this particular case based on those events, because, a choking or a smothering, that stops while the victim is still alive. I think that speaks strongly to a lack of intent to kill. And I think it is different from Justice Johnson's example of shooting someone, because, you can be fairly certain that a person's going to die from that unless you shoot them in non-vital areas. But
Tamika's description of that was 15 or 20 minutes of a choking sound?
of the labored breathing, she didn't say, I saw him choke her.
No, but the sound.
The sound.
I
and
thought she
think,
described the sound as a choking sound.
Right, and I think that was the agonal breathing.
But to an ordinary person that hears choking for 15 to 20 minutes, I don't think you have to have the medical knowledge to think this person's going to die because of this labored breathing. I think common understanding is if somebody's choking, they can die.
Or common understanding is also she's still breathing, she's alive, and I've stopped the bad thing that I was doing to her, and I've stopped without killing her.
And isn't the interpretation of what I said versus what you said a jury question?
I think if you have two possibilities that are equally likely, then I think you have a situation where you don't have proof beyond a reasonable doubt.
Any further questions of counsel? Any further presentation? I see you're out of time.
Thank you.
Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time the court is in recess for 15 minutes.